Today, now we are going for another session where we are going to introduce, as I said earlier, 5 new appellant counsels. Let me introduce. First one is Advocate Ila Garg, Advocate Rajat Gandhi, Advocate Rohit Sharma, Advocate Vishal Sharma, and CA Yugal Goyal. गायब हो गए हमारे युगल। The bench will be presided by none other than Advocate Rajesh Khurana ji. Yes, Justice Rajesh Khurana ji, and the judicial member will be Justice Rajmani Jindal ji, and accounting member will be Justice KP Singh sir. Okay. In our previous 12 Moot Tribunal, the government counsels was our mentors SV sir. Today he will assist all the 3 government counsels. First one is CA Rashmi Renu Sharma, CA Chandresh Gupta ji, and myself, and I bow down. So before we start the GST Moot Tribunal, I request SV sir to come here and present his views so that we can start the proceedings. So before I invite SV sir, I request Gandhi sir, please escort all the 3 judges. आइए सर, आइए सर। हमारी I request Registrar of the GST Moot Tribunal Vikas Mittal to take his seat. So stage is for SV sir for 5 minutes, sir.
Well, friends, today I am not the government counsel. They say that you will assist us with the research work. So wherever they think they need me, they'll call me. Welcome you all for this GST Moot Tribunal. Today we have 5 very important GST appeals. First appeal is the biggest appeal of entire GST regime. In my opinion, I think there can't be appeal bigger than this on the maintainability. The case is appellant has been totally negligent, where he has laughed at the authorities, never appeared before anybody, filed an appeal which is time barred without condonation application and has not disputed the full demand. That is, the demand was 1 crore 40 lakhs. The appellant disputed only 1 crore 60 lakh interest was not disputed. As we know, the appellate mechanism in section 107 is only on disputed grounds. So something we have not disputed, what happens? There is no condonation application filed. Now the appellant comes to appeal in tribunal. These are the question first on maintainability of appeal. First, maintainability of appeal. Second, can a ground be taken before tribunal to allow the appellant to amend the grounds of appeal after time barring limitation? And can the tribunal allow him to dispute the interest and go back to first ever authority? Or can the tribunal take a view right here when appeal is time barred? So it's also a question of jurisdiction of tribunal. Can this appeal be heard at all or should be dismissed at threshold? So the question is of what is valid appeal? That is the correct question of law that will be debated by Ila and Renu. Both are young lawyers, both are going to do this case perhaps for the first time in their life. Second issue is on composite supply, where an appellant takes a contract with a company, I will design you a menu, serve you food, get you quality food, etc., etc. And he says the entire supply is taxable at 5%. Revenue says no, this is composite supply where the principal supply is service. They will pay 18%. So interpretation of section 8 read with section 2 subsection 30 is another very good appeal for all of us to learn. Third is whether one transaction, two activities, one transaction are one or two. Where an appellant applied for a license to collect human hair from a temple, and the contract was that you will pay 18% tax. Tax was levied, adjudication order passed. He went in appeal dismissed, or whatever ground I don't remember now. So he is in tribunal. So whether this an integrated activity or license fee was separately than the picking of human hair. That is, if the sale of human hair was exempt, can we say the license fee should also be exempt? That is a third appeal. Fourth appeal is on RC cancellation, which is being done by Rohit. तेरा भी RC cancellation है? तेरा क्या है? हाँ, अच्छा. कहते मेरा तो उससे बड़ा है, फेक इनवॉइस है हमारा तो. Other cases which I have clubbed 6-7 High Court judgments in one case, where the adjudicating authority has put 29 to C instead of 2E. So whether this is a fatal error in the show cause notice, when all facts are given, the facts are that the entire story was fraud. He never had premises, landlord statement recorded, his wife statement recorded, I don't know anything about it. So his RC was cancelled retrospectively. Then fifth case is, there is a condonation of delay 1 day beyond 4 months. 1 day. And case of fake invoices. So whether in a condonation of delay a petition can merits be discussed, or the tribunal has to be concerned with only condonation, no merits, because limitation knows no equity. Well friends, these are the 5 cases. Hold your breath. There are going to be serious fireworks from both sides. Both have been trained in my office, so both have their solid points and they are not scared. Are you scared? Become Rani ki Jhansi. CA Revenue Sharma just tear her off. Come on, sit down. Okay? So all 5 young counsels whose mementos were given them in Candelval, now they have got the money also. They have to work hard. Fees paid in advance. So if you don't justify, money might be taken back double. God bless you. Thank you.
Friends, first case is Garg India Private Limited, represented by Advocate Ila Garg. As we sir said, the appellant has availed the input tax credit on the purchase of 2 Ferrari cars, and appellant could not prove that the purpose of utilizing these cars. Another issue in this present appeal is that appellant has not contested the interest in the first appeal. Moreover, the first appeal was filed after the prescribed period of 3 months without filing the application of condonation. Let's hear both the new appellants and the government counsel. Let's welcome Advocate Ila Garg and CA Renu Sharma.
At the outset, I would like to thank SV sir for providing me, even us, this platform which helps us to develop and enhance our practical advocacy skills. Before I commence my submission, I seek indulgence of the Honorable Bench. This being my first matter before the tribunal, I request that minor inadvertent errors may kindly be overlooked. I shall be grateful for any guidance or observation of this Honorable Bench which may assist me in placing the matter appropriately.
Sir, I have on both the sides. I can't say that. I can only good luck both the sides.
This present appeal has been preferred herein aggrieved by the order dated 19th January 2026, wherein the learned adjudicating authority dismissed the appeal filed against the assessment order passed by the proper officer under section 74A for the financial year 2023-24 in the DRC form DRC 07, confirming the tax, interest and penalty on account of alleged availment of ITC in violation of section 16(1) read with section 17(5). The grounds
मैडम काउंसिल ये बताइए कि इसमें आपने जो अपील फाइलिंग की फीस होती है वो कौन से पेज पे लगाई है, इंडेक्स में देख के बताइए।
मैम पेज नंबर 4 एंड जो उसका DRC 07 के साथ पे हुआ था उसका है पेज नंबर 32।
मैम ये तो 6 लाख का है।
हाँ यस मैम।
तो अपील फाइलिंग फीस कहाँ पर है? सेक्शन पढ़िए, 107(6) पढ़िए जरा।
Yes, ma'am. Yes, ma'am. हाँ
सारे एकदम क्वेश्चन पूछेंगे तो try to encourage the appellant not put so many questions.
मैम 112(7) निकालिए, फाइलिंग फीस का जो सेक्शन है वो निकालिए जो आपने फाइल करी है फी। और कौन से सेक्शन में फाइल करी है आपने? 112 में करी है ना?
हाँ जी।
हाँ तो उसका 112 सेक्शन निकालिए, बताइए।
राइट मैम।
112।
Yes, it says that it shall be accompanied by such fees as may be prescribed. I apologize, ma'am, and I'll put this fee into record.
मैम फाइल कैसे एंटरटेन की जाएगी जब आपने फाइलिंग फीस नहीं फाइल करी? दूसरा, अभी आपने DRC 03 लगाया है, इसके लिए आपको जो फॉर्म यूज़ करना था वो PMT 06 यूज़ करना था, और फिर आपने ये फॉर्म भी देखिए गलत फाइल करा है, गलत भरा है बिल्कुल। खोलिए फॉर्म सर, आप कौन से पेज पे?
पेज नंबर 4।
ऑर्डर में लिखा हुआ है कि आपने इनपुट टैक्स क्रेडिट यूज़ करके ये फीस जमा कराई है, आप यहाँ पे कैश मेंशन कर रही हैं, डेट गलत है आपकी यहाँ पर।
मैम जो ये प्री डिपॉजिट है वो मैंने कैश लेजर के थ्रू पे किया। जो प्री डिपॉजिट है वो मैंने कैश लेजर के थ्रू पे किया।
तो दोनों दो है ना प्री डिपॉजिट मैम, एक तो अपील का और एक ये है।
हाँ जी।
हाँ तो कौन सा आपने डेबिट लेजर से किया है?
मैम जो और आप जो बात कर रही हैं, एक सेकेंड।
मैम आपने कैश लिखा है,
Yes, ma'am.
इट्स रॉन्ग, फैक्ट से गलत है। फिर आप ये यहाँ पर ये IGST हरियाणा POS क्यों लिख रही हैं, ये भी बताइए। फॉर्म भी गलत है आपका, है ना? तो वो
हरियाणा मैम मैंने इसलिए लिखा है क्योंकि जो मतलब डिमांड थी वो IGST में निकली है और परचेज जो हुई है वो हरियाणा से हुई है।
अच्छा चलो ये वाली बात आप ये मान लेते हैं। PMT 6 फॉर्म ये है मैडम, दिस इज द फॉर्म, इट शुड बी यूज्ड, आपने ये यूज नहीं करा है। अच्छा सबसे बड़ी बात है आप अपील आपने साइन ही नहीं करी है, इट इज नॉट साइंड एंड वेरीफाइड, हाउ दिस अपील कैन बी एंटरटेन्ड?
माय अपॉलॉजीज मैम, आई विल मेक द करेक्शंस एंड आई
मैडम
रिक्वेस्ट यू,
आपने अपील
आई
फाइल
रिक्वेस्ट,
करने, जस्ट
हाँ।
मोमेंट, आपने फीस जमा नहीं कराई,
यस मैम,
फॉर्म गलत भरा है चालान का, ठीक है, फिर उसके बाद आपने वो साइन तक भी नहीं करी है, उसको वेरीफाई नहीं करा है, कोई कॉन्डोनेशन की एप्लीकेशन नहीं है सब। अच्छा 107 सेक्शन निकाली, उसमें सफिशिएंट कोज के बारे में लिखा हुआ है, आपने सफिशिएंट कोज कहीं पर दिया है मुझे?
यस मैम।
बताइए।
मैम कॉन्डोनेशन एप्लीकेशन इज देयर ऑन पेज नंबर
नहीं मैम मेरा क्वेश्चन ये है
along with the
कि
sufficient
जो
cause.
सफिशिएंट कोज की बात करता है सेक्शन, वो
Yes, ma'am.
107(4) में, वो आपने सफिशिएंट कोज कहाँ,
I
सफिशिएंट कोज एक एक दिन का एक्सप्लेन करना होता है मैडम।
yes ma'am. Page number 42 है. Actually my father was not doing well. There was some medical emergency. So if you wish, I may attach his hospitalization bills details as well. I have annexed the certificate as well.
इसका मैडम जो फॉर्म भी होगा ना,
Yeah,
वो भी
this
आपने
is
एनेक्स
on
नहीं करा,
page
This is
number
the just
42.
नो नो दैट
Yeah.
इज ओके, बट आपने ये इसके साथ जो फॉर्म होता है ना, जो जी स्टेट रूल्स में जो प्रिस्क्राइब फॉर्म है, दिस इज द जी स्टेट फॉर्म नंबर 1, दिस यू हैव नॉट एनक्लोज्ड, नॉट फाइल्ड।
नहीं okay ma'am.
तो ये आपकी एप्लीकेशन कैसे एंटरटेन होगी? दिस इज द फॉर्म।
I wasn't aware, ma'am. I'm really sorry. This is my first appeal. I again bargain for your mercy.
Ma'am,
हाँ,
these are not the small mistakes.
I-
These are the main mistakes. How it can be termed as a valid appeal? Tell me. Sufficient cause कहीं पर भी आपने एक्सप्लेन नहीं कराया मैडम,
ma'am, page number 42.
और टैक्स आपने जमा नहीं कराया, एडमिटेड टैक्स जो भी था 8 लाख रुपए, आपने 6 लाख जमा कराया है,
हाँ जी.
जो 8 लाख इंटरेस्ट का अमाउंट है,
Yes, ma'am.
जो एक तरह से एडमिटेड टैक्स माना जाएगा क्योंकि आपने उसको डिस्प्यूट नहीं करा।
Ma'am, I have mentioned this again in the form 5 that it is under the disputed category. If you refer the form 5, it says it has 2 columns, disputed and admitted.
Okay.
In both the columns, I need to write the amounts. I agree that I forgot to write the interest amount against the disputed column. However, I didn't even write the amount under the admitted column. Even if you go through my appeal filed at the first appellate level, I have contested that appeal. Though I forget to mention that in the form 05, but appeal number APL 02, but I was always intended to contest that part as well.
अच्छा मैम बहुत सारा वेरिएशंस है मैडम आपका, APL 2 में आप कुछ और फॉर्म डेट लिख रही हैं, फिर आपने वकालतनामे में कुछ और डिटेल लिख रही है, और ये जो आपने APL 5 भी जो फाइल करा है ना मैम, ये कंपनी है, इट शुड बी वेरीफाइड बाय द कंपनी विद रबर स्टैम्प, इट्स नॉट साइंड एंड वेरीफाइड, नो वेयर नो साइन, नो सिग्नेचर, नो रबर स्टैम्प, नथिंग इज देयर।
Ma'am, being it is a moot tribunal case, ma'am, I request you for the adjournment. I'll get it rectified within few time, if you please allow.
So at the outset, it is submitted that the present appeal is liable to be rejected at all, as time time barred by the limitation, the appellant had filed the appeal beyond the period prescribed in 107 subsection 1 of the CGST Act without filing any application seeking continuation of delay and without placing any material on record explaining the circumstances which prevented him filing of the appeal within the prescribed period. Now the power of continuation under section 107 subsection 4 is not automatic. It is a discretionary statutory power which can be exercised only upon satisfaction that the appellant was prevented by sufficient cause from filing the appeal within limitation. In the present case, the appeal memorandum does not contain any prayer seeking continuation. No separate application for the continuation has been filed. No affidavit explaining the delay has been furnished by appellant. No fact constituting sufficient cause has been pleaded. Therefore, the appellant has failed to invoke the jurisdiction vested under section 107(4). Here is the Supreme Court judgment also on this. In Assistant Commissioner CT LTU Kakinada and Ors versus GlaxoSmithKline, held that where a special statute provides its own limitation scheme, the statutory timelines must be strictly followed. And the court emphasized that the appellate remedies under the special enactments are subject to the conditions prescribed by the statute itself. So the CGST Act already provides a complete mechanism under section 107. The appellant cannot bypass statutory requirement by filing a delayed appeal without seeking continuation. So the appellate authority cannot presume sufficient cause on its own for granting continuation. My lord, the expression sufficient cause requires the appellant to demonstrate a genuine circumstances preventing timely filing. A mere statement like a lack of awareness or negligence or internal administrative difficulty or any failure to monitor GST portal or advice of consultant without any details cannot automatically constitute the sufficient cause. That burden lies upon the appellant. The appellant cannot simply file a delayed appeal and seek admission as a matter of right. The delay must be explained there and the continuation jurisdiction must be invoked there. Appellant had not invoked any discretionary jurisdiction vested in the appellate authority under section 107(4) of the CGST Act, and a delayed appeal cannot be treated as a valid appeal at all. मतलब बाकी सारे आपके तो डिफेक्ट्स तो बाद में ठीक हो गए, अभी तो ये वैलिड अपील ही नहीं है मेरे अकॉर्डिंगली.
मैडम आपने सर्टिफाइड कॉपी ऑफ द ऑर्डर नहीं लगाई, विच इज़ द मैंडेटरी रिक्वायरमेंट. अगर वो नहीं मिला था टाइम पर तो आपको उसको सेल्फ अटेस्ट करके लगाना चाहिए था, वो भी आपने नहीं लगाया इवन. ठीक है ना. APL 2 जो आपने लगाया है उसमें डेट गलत है. ठीक है ना. मैडम जो बोर्ड रेजोल्यूशन भी है सभी में, अगर कंपनी का मैटर होता है बोर्ड रेजोल्यूशन लगाया है आपने, देख लिया मैंने दोनों केसों में 2 बोर्ड रेजोल्यूशन लगाए हैं आपने, लेकिन उसको कंपनी की रबर स्टैंप लगाकर पूरा उसमें साइन वगैरह करवा के देना चाहिए. वकालतनामे में भी मैडम कहीं पर भी साइन करके पूरा रबर वो जो भी अफिक्स करते हैं रबर जो भी स्टैंप होती है कोर्ट की वो लगा के पूरा उसको करना चाहिए. कहीं पर भी उन सब बातों का ध्यान नहीं रखा गया है, तो इसमें लॉट्स ऑफ डेफिशिएंसीज है. It's not cannot be called as a valid appeal.
Ma'am, I
so
request.
work on this more.
Yeah.
First of all, there are certain procedural limitations about which you have heard a lot from my friend this side and also from the council. Assuming for a while that we condone all those things, because in any case procedural limitations should not override the substantial relief in this. But my worry is bigger one. And bigger worry is, what do you get by getting this order quashed and getting it remanded to the first appellate authority?
Sir, in this regard, I wish to submit that the acquisition of the Ferrari motor vehicle was not for the personal consumption, but for the business purpose. The vehicle was were procured pursuant to the bona fide business expansion plan.
My lord, may I request?
No, sorry. Let her finish first, then you return.
The vehicles were procured pursuant to a bona fide business expansion plan, for which I have attached here with the business plan as well. And the submission of the officer that there had been the fraudulent intent, as the purchases were made in the month of June 2023, but the credit thereof was claimed in the quarter ending March of 24. So with respect to that, that the applicant is engaged in the field of cinematography, event management and media related services, commercial activities, and the applicant had proposed a business dedicated luxury vehicle segment catering to the film production houses, celebrity management assignments. And since the business model contemplated deployment of high-end luxury vehicles including the Ferrari cars, and rendering services to the actor, actresses, production houses, the vehicles were procured for this aforesaid proposed business vertical. There was no concealment of the facts, misrepresentation or intention to evade the taxes. Since the commercial model was under evaluation, the credit was not consciously availed at the time of the procurement. Upon the finalization of the proposed business plan, during the financial year of 2023-24, the applicant availed the credit in the month of March 24. That is within the time limit permitted under section 16(4) of the Act. The delayed availment itself demonstrates that the applicant did not mechanically or fraudulently avail the credit. Had there been any fraudulent intention, the applicant would have availed the credit in the month June itself. The fact that the credit remained unavailed for several months itself negates the allegation of the fraud. Neither the proper officer nor the applicant authority conducted any inquiry relating to the proposed business or the commercial rationale behind the procurement, the accounting treatment and the business plans of the assessee. Finding the vehicles were obviously meant for the commercial purpose and for the leasing to the production houses. This can be proved that the credit can be.
Yes, my lord. My lord, ये सारे तो merits के point है, but मेरा point ये है कि अपील ही valid नहीं है. जब वो फर्स्ट अपीलेट अथॉरिटी में ही डिसमिस हो गई ऑन द पॉइंट ऑफ कंडोनेशंस, तो हमारा तो रिस्पेक्टेड ट्रिब्यूनल का तो जुरिडिक्शन ही नहीं हो उस अपील को एंटरटेन करने का ही.
My lord, I would like to submit.
One second. I have two issues on this. At the time of the first appellate authority, she did not find sufficient cause for condonation of the delay. She did not mention anything. What to speak of submitting the formal condonation application, she did not even orally tell the appellate authority that these were the reasons. No. See, it is not your fault. We advocates are like doctors. Case came to you when it has already passed. If it is a cancer patient, it has already passed stage 2. It has come to you at a stage 3. So you can't go back in time and cure it. But let me say that my worry is that you are going a little wrong on strategy, because now that sufficient time has passed between the time the vehicles were procured, and you took 9 months to decide whether these vehicles, even though they have been procured, invoice has been got, whether these will be used for running of the taxis or they will be used for staff car. You took 9 months to decide that. No, 1 second. And it took na?
Yes, sir. Actually, the business plan was under evaluation.
Doesn't matter.
Sir, we received our first order for this in the month of January 24. So accordingly, we claimed the credit in the month of March 24.
Okay.
Also,
admitted.
But the fact is that it took 9 months, no?
Right.
एक मिनट. Admitted. Now, after 9 months, you decided that these vehicles will be used for running of the taxis.
Exactly, sir.
Okay. What kind of a registration you got from the transport authorities?
Sir, I have attached this.
Was it as a personal car, staff
No,
car?
we got it converted into the commercial purpose, for the commercial purpose. I have enclosed the insurance bill as well, insurance policy as well. It is on page number 41, which says that the usage will be for the...
Something different. No, it is a service agreement.
No, there is a policy, insurance policy extract, which says
मैडम
that
जिस जो व्हीकल लिया जाता है वो उसमें पूछा जाता है ये प्राइवेट के यूज के लिए होगा या कमर्शियल यूज के लिए होगा
Right,
तो आपको
ma'am.
वो पेपर लगाना चाहिए था ना वो आपने नहीं लगाया
ma'am, we have got it converted into the commercial, and it says the insurance policy says that the vehicle usage will be for the commercial or the business use. If you refer,
There is a difference between business and commercial. Even when you use it as a staff car, it is both business and commercial both. If you use it for the use by the
sir,
director.
that in that case the policy would be for the personal purpose.
Okay. Now, in order to avail ITC and not having to reverse it, you have to use it only for three purposes. One of the three purposes, all the three purposes.
Right.
You remember that?
Right.
Either for selling the same further,
Yes, sir.
or for driving school, or third is for transportation of the passengers. Out of these, did you use it for any of these three purposes?
Sir,
Are there
I-
sufficient invoices to show that some revenue you have earned on account of that?
Sir, I have rendered it for the purpose of leasing it. For the purpose of leasing the vehicles, as allowable under the provisions of the CGST Act. Also, I have received the incomes from this starting from the month of April 24.
No, you have placed only two invoices. One is for 1 lakh rupees and another is for 180,000 rupees. 40 and 41. So
Sir,
that,
one
you see,
lakh- yeah.
that will substantiate only if you have a very huge amount of consideration, huge
Sir,
amount
but,
of services.
Right, I agree, sir, but this is for the one day. This
is
this consideration is for one day.
this is just a quotation
No, ma'am, this is the agreement.
on
Page number 41.
40.
Page number 41, we got the first contract relating to this business expansion in the month of April 24, and that is for one day. For one day we got 1,80,000 consideration. So we are planning to get about 60 lakh throughout this year, even more than that.
So for that you must have placed copy of balance sheet that will substantiate that you
Right,
have used it for
I can
commercial
produce
purpose.
that, sir.
बट माई लॉर्ड मेरी रिक्वेस्ट ये है कि ये अपील ही इंटरटेनेबल नहीं है यहाँ पे,
Sir, मैं
That
बट
is-
स्टिल हम मेरिट
हाँ।
सुन रहे हैं,
मैं
मतलब
सर
हम
इस
डिफेक्ट
चीज-
सुन रहे हैं, बट ये अपील यहाँ पे इंटरटेन होगी कि नहीं होगी?
Sir,
If
मैं
the
इस चीज में
appeal
एक
has
चीज-
been placed before this bench, so we will consider everything, even merits, its offs and ons. We will.
See,
everything.
her request for condonation was not placed before the first appellate authority, it has been placed here.
बट जब अगर अपील ही हमारी वैलिड नहीं है तो उसके बाद अब एडिशनल डॉक्यूमेंट्स जितने भी लगाते हैं वो भी वैलिड नहीं है,
Sir-
बिकॉज आपकी अपील इटसेल्फ ही इनवैलिड थी.
Madam, we have already taken cognizance of that there are many infirmities in the procedural infirmities. Let me use the word procedural infirmities, and in the interest of justice, we have decided to not overlook them, but we have decided to condone those. Now the issue is more on facts, whether the vehicles have been used for the purposes for which the ITC could be allowed, or it had to be reversed. That is the material fact. And second is, and this is not visible from the paper that are before us. What we decide to do is, we try to undo the first appellate authority, asking him to condone the delay, but remand it back to the either adjudicating authority to look upon whether the vehicle has been really used and ITC was not blocked under 17.5 and it was used for the three purposes for which the ITC could be allowed. Now hearing this kind of a thinking, yeah.
Sure. Sir, if you don't mind, I wish to submit one more thing.
My lord, this appeal tribunal has no jurisdiction to hear. This tribunal has no jurisdiction to hear this appeal. Let me place facts. Appeal was filed after 4 months. Can tribunal condone this delay?
Not 4 months, after 3 months.
3 months.
Right, 3 months, few days. There was no contradictory application filed.
Yes, that is a
No sufficient reason, not pleaded, admin tax not paid. Right? That's the ground in adjudication order. My lord, let me speak, then you take adjudication, whatever you want to take. I have no issues. I'm not against her or against client, I'm stating law. Sure, you mean to say appeal is filed late, which is not a valid appeal because admit tax was not paid. Admitted amount of interest was not paid. So do you think this tribunal can condone this and ask them to pay admit tax? Will you extend limitation? No. I'm saying interest is not paid, 60 lakh not disputed.
No. Let me answer that. There is a clerical error in writing the interest amount from that what is called as interest.
Disputed column.
No, my lord. It's a question of appellate order. I'm not talking of Appeal 01. There's a finding in appellate order. Interest is not disputed nor any arguments taken place. It's a part of appellate order. You can't go into finding of appellate order. This tribunal cannot go.
Hello.
Sir, everybody should get the opportunity to make the bad good. Even if I go with the order passed, the show-cause notice is passed by the authority, proper officer, and even the...
may not hear me out. She can speak whatever, she'll speak later. Let's read the appellate order. This tribunal has to have jurisdiction to hear this appeal first. Condonation merits have no value at all. Equity has no value, no limitation. It says the appeal has been filed against. You got my lord?
24.
The appeal has been filed against the order passed under by the proper officer for 2024, creating a demand of 60 lakh towards tax, 8 lakh towards interest, and a penalty of rupees 60 lakh. The appellant was issued show-cause notice, further notices that were duly served in person on the advocate of the firm and on the director of the company, but neither apply such a defiance to authorities of law. On advocate notice was served, director notice was served, they don't appear. The proper officer by his letter dated so-and-so therefore decided the issue and created the demand. The appellant has purchased 2 Ferrari cars worth 2.5 crore, has claimed input tax credit for the same. You have claimed and utilized the ITC to the extent of 60 lakh on such 2 cars. 60 lakh ITC has already been used. This is a finding of fact. सारे पैसे लगाओ ना जेब में तब फायदा इसका क्या फायदा Enquiries made by the professor reveal that there is no business of sale or purchase of car that you are engaged, nor you are engaged in renting a cab type. This is a cook and bull story now created in second appeal. Such luxury cars also cannot be used for transporting of goods. Hence, the input tax credit claimed by the appellant in the opinion of the proper officer in violation 16(1) so and so. The proper officer has also found their input tax credit was claimed with an intention to evade tax. This is a finding. This tribunal cannot reverse the finding until tribunal is empowered to appreciate the evidence in a case of limitation. This tribunal has no jurisdiction whatsoever. And willfully suppressing the facts, it has been found by him that the appellant had no input tax credit in electronic ledger. Just to adjust the output tax liability, he adjusted the input tax credit that he paid to the car dealer for purchase of the above 2 Ferrari cars. That has no connection with his business at all. Let me speak, sir. Allow me to speak. We are having Supreme Court judgments. If tribunal thinks you can ignore Supreme Court, I'll be with you. The cars were obviously meant for personal use of directors. Nothing has been proved that for 9 months these cars were ever used by them. It will hit 17.2. Let me commit, sir. This is a very big case I told in the beginning. Further, the proper officer has found that the cars were purchased much prior to date of claiming availing utilizing input tax credit, making a strong case for fraudulent claim of ITC. In his view, his case was further strengthened when the appellant chose not to appear at all either before the proper officer or any show-cause notice. Such a defiance of law. So, if such appeals are even entertained, this will be abuse of process of law before the tribunal. Let's read further. The appellant has filed this appeal by depositing 6 lakh, 10% tax depart, adjusted tax rate is available in the electronic ledger. No cash has been paid.
Yes, this is what I
Now, this is a concealment of fact. No cash has been paid. They adjusted by adjusting 60 lakh in Ferrari cars. Now they filed appeal by adjusting electronic credit ledger. No bar they can do if it's available. The appellant had disputed only the tax amount and penalty amount has not been disputed. The interest amount in AP is well. The demand disputed is so and so. In other words, clear that the appellant has admitted the interest company 8 lakh but has not deposited the same as admit liability as required in section 107 of CGST Act. We will read 107. Hence, the appeal cannot be entertained and is to be dismissed in limine and accordingly dismissed in limine. There is another ground of dismissing appeal. The appeal has been filed against the order in original 19 thus and appeal should have been filed 19 ek, but the appeal was filed of 10-2. It must have been filed on 19 months, beyond 3 months, within a month condonable period. There is no application for condonation or delay filed, nor this fact has been brought in memo. My question is, appeal is dismissed. 3 months plus 1 month are over. Can this tribunal hear this appeal after 4 months? Sir, we'll answer all the questions. First, my question is that this tribunal has no jurisdiction whatsoever in any law to even touch this appeal. I'll give the Supreme Court on this.
I think we should be taking one by one, issues one by one. One is your dismissal in limine because at the first stage he did not take any stand on whether any reasonable cause was there for condonation of the delay. That's one. Do you agree with that?
No. So one sec. If it's not simple, it is neither pleaded in round of appeal, nor application, no oral submission.
That's what I'm saying.
No, sir. It's there's the difference. Simply not taking is not enough.
That's what I'm saying. It says
Act law.
107.3, where in pursuance of an order under 2, the authorized officer makes,
104.
Appellate authority may, if he is satisfied that appellant was prevented by sufficient cause from presenting the appeal within the aforesaid period. That means he could have condoned if sufficient cause was shown. At that time, sufficient cause was not shown, but now the sufficient
No, it's not shown. It's not simple. Show cause notice not replied, no appearance from appellate authority. It's a defiance.
For defiance, she has suffered. She got the adjudication.
No, she has not suffered. No, she has not suffered. Now the appellate wants is this tribunal should extend the limitation beyond 4 months. I'll give you Supreme Court on this. It's the latest judgment. Let me go through this, sir. First, let me go through the order. नहीं अवार्ड गवर्नमेंट काउंसिल की आवाज तो ना कम होती है अगले के उधर आके धीरे बोलूंगा.
Sir, the entire proceedings have been initiated.
Let me see.
And he says even on merits, keeping in view the factual matrix, an absolutely casual approach would expire to notice the orders and for appeal filing the appeal is liable to dismiss merits. Accordingly, appeal has no merits. Here also, nobody appeared. You mean to say show cause notice, further notice, adjudication, appeal, nobody appears. Now let's come to law. We have answers to all the questions you can possibly raise. Subsection 1. Give me time. Have patience.
Please.
Any person aggrieved by any decision or order passed under this act or the state, goods and so and so, by an adjudication authority may appeal such so and so. Now, first we come to section 107, subsection 6, not 4. No appeal shall be filed. Language is this. No appeal shall be filed. There is no question of any condonation whatsoever. No appeal shall be filed under subsection 1 unless the appellant, first no, then unless, these are very negative words, has paid in full such part of the amount of tax, interest, fine, fee or penalty arising from the impugned order as is admitted by him. Right? So what do you mean by admitted?
Admitted means that this is really payable, yes.
Huh?
Yes.
No. The law have used word admitted.
Yeah.
Right? So APL was formally only for this purpose.
Yeah.
Right? So when I get caught, I say मेरा clerical error हो गया. 8 lakh रुपए.
Okay. If you write in the column admitted or do
No,
not
there is no
write
question of writing. No. We'll give you Supreme Court on this, sir. We are ready. If it was so simple, then though this 1076 shall become odious, then any tribunal will start giving orders. There will be a flood of orders before the tribunal. Let's go further now. 1074. The appellate authority may, if is satisfied that the appellant was prevented by sufficient cause from presenting the appeal within the aforesaid period of 3 months or 6 months, as the case may be, allowed to present it within a further period of 1 month. Right? Now, look at the ground of appeal. They said there is no requirement of filing a formal constitutional application.
Yes, sir.
I have to read the appeal, sir. We'll answer all your questions completely.
So the procedural laws to facilitate justice.
No, that's not a procedure. Your appeal is unsigned. When order is unsigned, you say that officer has order is illegal. Your appeal is unsigned, you say that this appeal can be entertained.
Sir, I would like to say, submit that the entire.
No, wait. Let me finish. You do. Take your time. Don't worry. We're in no hurry. Just read page 14, sir. The impugned order does not record any finding that delay was deliberate, intentional, or lacking bona fides rather. How will appellate authority record a finding? He doesn't know what have you done. Will he assume, sua motu assume? No, wait, sir, wait further, wait. Look at the language used. They are taking on the law. Rather, the appeal has been dismissed solely on the ground that no separate application for condition was filed. So obviously, आगे देखिए. The statute nowhere provides that absence of formal application automatically extinguishes appellate remedy. It does. It does without fail. There is no need for without application. How you prove sufficient reason? Let's go further on this issue. Let's pick up 112.1. When I say tribunal has no jurisdiction, I say as per law. You got that? That's a section 112.1. Any person aggrieved by an order passed against him under section 107. This tribunal has jurisdiction only into disputed areas of appeal. We cannot create suo motu contentions. Ferrari kya hua, uska kya hua. That is not discussed below. This tribunal has no jurisdiction.
The only issue is whether the dismissal was okay or.
That's all. There is no Ferrari. The appellant can go to hell with Ferrari. We have no issues. How can tribunal hear on merits? Let's take it further. You know, my colleague Renu has quoted the judgment of Glaxo. It was exactly same case Andhra Pradesh. Same provision, 3 months, 1 month. Revenue went in appeal before Supreme Court. Delay was condoned. Supreme Court said, how can you condone delay? Under what power? What power you have? They did not. Let's take a further judgment. The appellant cannot simply file a delayed appeal and seek admission. Now the appeal has come to you after 4 months are over. Allow me to answer. Now if this tribunal has to help, you have to allow this rectification of a defect of admitted tax or whatever after 4 months. You cannot convert a completely invalid appeal into a valid appeal. It's not possible. All this was to be done within 4 months. Only then is a valid appeal. We'll go to Supreme Court on this issue.
Sir, it is done within 4 months.
I'm reading Supreme Court para, then I give you judgment also. A valid appeal satisfying all statutory requirements must be filed within the maximum permissible period. That is 4 months. Subsequent rectification, removal of defects cannot be treated as extension of limitation. Appeal is not signed. What could be more fatal? This is not a matter of procedure. Can I give you a check unsigned? You say, I'll sign it later after 2 years? Filing fees, forget those part. That is, the rectification is only for defects which are deficiencies, which are minor. Rubber stamp is not there, yes. But where the basics of appeal have not been completed, this tribunal can never exercise jurisdiction. I'm going to go to Supreme Court on jurisdiction also. Subsequent rectification, removal of defects cannot be treated as extension of limitation. Defective or incomplete filing cannot preserve limitation. unless the statute recognizes such filing as a valid appeal. So now if you allow this to happen, this tribunal cannot hear this appeal, that's for sure. On merits, you are hearing limitation. So now you will ask the appellate authority to accept the appeal after 7 months.
Okay, we confine ourselves to the limitation issue.
Okay, now, Vedant, let me continue.
Yeah.
Then we will continue. The appellant cannot claim the benefit of the original filing date merely because the certain defects were subsequently cured. Limitation applies to filing of a valid appeal, not to a proposed appeal incapable of being entertained in law. This appeal is totally incapable of being entertained in law. Not even High Court can rectify it. Even Supreme Court says so. I'm not saying that. I'm reading Supreme Court only. The statutory right of appeal under section 107 is conditional upon compliance with the requirements prescribed under the Act and rules. Once the maximum period prescribed in 1071 read with 107 expires, the right of appeal stands extinguished. It's over. Not where the appellant goes, that doesn't matter. Rectification of defects subsequent there cannot operate as an extension of limitation or revive a remedy barred by statute. So what tribunal is trying to do by condoning delay and remanding the matter, this tribunal is exercising extrajudicial power to revive an appeal which is time barred. Let's say I'm quoting a Supreme Court judgment in Melaram case. I'll give you this paper. If you want full judgment, we'll give you. And they follow, and it's followed in Honga India Singh Enterprises. My lord, they're aware. A taxpayer cannot argue that a defective file was uploaded filed within time. Subsequent correction of defects after expiry of limitation gives it the benefit of the original filing date. It's not possible. The Supreme Court held, therefore, the appellate authority derives power of condonation only from the statute. This tribunal has no power like section 151 CPC. There is no power, there is no inherent power. Tribunal is a creation of statute. Once the authority prescribed the control period expire, no authority can enlarge limitation. No authority means including Supreme Court. They did not in this case. Our argument is, if the appeal was not a legally valid appeal within the present period, later rectification cannot revive a right already extinguished. That's another judgment of United Commercial Bank. A procedural requirement prescribed for filing an appeal cannot be treated as a mere formality. This is not a formality. Your right of appeal depends on this. Is your appeal signed? Have you paid the fees? Have you moved under the application? Have you explained reasons? These are not matter of procedure. They say no. This is not a mere formality where it affects the statutory right of appeal. A right of appeal is not given by constitution. If the statute gives a put a condition, whatever. This again Supreme Court in the same case observed. An appeal presented within time but defective may in certain circumstances relate back to the original date after removal of defects. Right? Now what are the defects? However, the filing must be a recognizable appeal in the eyes of law. So appeal ही नहीं है, sign ही नहीं है, तो बात ही खत्म होगी सर. और what this tribunal can recognize this appeal. Next, another judgment, Ketan Parekh. It's a very famous judgment we all read when we were students. The Supreme Court emphasized that statutory appeal provisions must be complied with and procedural requirements cannot be ignored where they affect the assumption of appellate jurisdiction. So if this tribunal has to assume appellate jurisdiction in section 1112 subsection 1, the bench has to satisfy that all the procedures were fully satisfied, allowing additional ground. Now she sought an additional ground of interest. It's not possible. It's beyond this tribunal or beyond Supreme Court. What Supreme Court says? The CGST Act consciously prescribed limitation periods to ensure certainty and finality of tax proceedings. If the appellant was permitted to introduce new grounds after expiry of limitation, it would defeat the legislative intent. So tribunal बोलेगा 8 महीने कोई बात नहीं, we consider it, we condone it, and render section 107 limitation provisions ineffective. Such an approach would permit an appellant to bypass the statutory scheme by filing an incomplete or delayed appeal and subsequently improving it after expiry limitation. Let us say appeal was filed manually. 10% was not done. वो कहते हैं मेरे आग लग गई थी, मेरा कोविड आ गया था, मेरे घाटा हो गया. So can tribunal say after 8 months, के deposit 10% you hear the appeal? Tribunal. I'm not talking of High Court. why condonation application was essential? If the appellant has the guts to say the application is not required, this is shocking. No sufficient reason, even tribunal will suo motu assume, appellate authority should have assumed, and his right will, appeal will not get then the whole Section 3 Limitation Act. Supreme Court says even if limitation was not pleaded by revenue or by the appellant, this is the duty of the tribunal to ensure the appeals are filed with the limitation. Even if it's not pleaded, इधर तो plead हुआ है कि time bar है. Section 1074 does not prescribe any separate application for filing the application on delay. This is the appellant. The appellant is required to make a specific prayer, even it was mentioned in grounds of appeal. Sometimes that can be taken as an averment that my delay should be condoned. The whole case is built on total white lies and token bull story. In fact, there should be a heavy cost on this appeal. They are wasting time of tribunal, they are wasting time of revenue, and they are filing appeals which are totally baseless. The appellant is required to make a specific prayer invoking discretionary jurisdiction. Limitations are of two types in law. One is a statutory limitation, which is 3 months. 1 month limitation is a discretionary on the appellate authority or the honorable tribunal. 3 months is section 112. That is not a statutory limitation. That's a purely your discretion. And that is also conditional if sufficient cause is shown.
If sufficient cause is shown.
That's also conditional. Therefore, filing a application is necessity to enable adjudication delay, but law generally does not require a separate title document called conditional application in section 107. By implication, if the appeal member itself contains reasons, appellate authority should have considered. Should have. Not necessarily he can consider. Now there are series of High Court judgments. Delhi High Court, Eticam Specialty LLP versus Special Commissioner, 26/7/14 की judgment है, उस GST में है. You have gone through, then I need not go through, sir. Bharat Agro, I'm sure you have gone through that also. This is also Delhi. Appeal under section 107 was filed beyond the permissible period. The applicant sought direction for condonation. They say no, you can't condone. Then there is one more judgment of Allahabad High Court. See, if this tribunal really consider, you are invoking section 5 Limitation Act, not applicable. It is held in series of judgments by GST law. Section 5 has no meaning. So even on this ground, this appeal cannot be entertained.
When you say Eticam, means all those things are
already considered.
I am aware.
My lord, thank you so much. Now, let's understand what is section 107. I have done a lot of research personally on this issue because I'm so anxious to know what is the scheme of this section 107. The appellant has consciously confined its challenge to tax demand and has not raised any ground disputing levy of interest. Can this tribunal say this was a bona fide error? Can this tribunal, for that matter, can I presume this was a bona fide error? You are drafting an appeal. If you have not gone through the provisions, you were negligent here also. There is no benefit. They can't take out this clerical error. You should have appeared before appellate authority. You were within time. He could have allowed rectification. He could have allowed. Not this tribunal. This tribunal has to restrict its jurisdiction to section 107. In absence of any challenge, the interest liability arising from impugned order constitutes an admitted amount. Conversely, in terms of section 107, 6 subclause A, payment of such admitted interest was a mandatory precondition for maintaining the appeal. Since the appellant failed to discharge the liability, the appeal is liable to be rejected as not maintainable. For dismissal of appeal, the stronger statutory ground is section 1076, non-compliance. Non-compliance can never be bona fide. इधर भी यहाँ भी कुछ नहीं लिखा है. अभी वो बोलते हैं interest is consequential. Section 107 doesn't talk of any consequentiality of interest. I don't know what kind of argument is that. Rather than merely saying interest was not disputed, then non-dispute of interest in appeal may be treated as acceptance, admission of demand. Now, what is the scope of section 107? This honorable tribunal can examine only disputed matters. What are disputed matters? Time barred, enemy tax not paid, and complete non-cooperation of the appellant. This is a good ground for condonation. But here's a total defiance. Even here also there is a complete defiance. Section 107, the appellant is required to specify the ground of appeal and the relief sought. If the appellant challenges only tax demand, does not challenge interest, does not raise any ground against levy of competition interest, then the appellate authority can legitimately infer that interest demand has attained finality. Can this tribunal say, no, interest तो consequential था, तो नहीं किया तो कौन सा होगे बात होगी? फिर तो I think the whole section 1076 will go for a 6. We will go against the legislative intent of the parliament if we follow this. There is another ground taken. Appeal before tribunal is a continuation of a valid appellate proceeding. No, only if the appeal is valid. This is what the court says. Once revenue is able to maintain or the honorable tribunal agrees, not a valid appeal, it is not a continuation of any proceeding at all. It's an independent provision. Now, seeking additional ground, do you think can additional ground create jurisdiction where none exists? Can this tribunal allow this? On appellate jurisdiction, there is Supreme Court ruling, and I'll give you all these papers as it is. NTPC, the Supreme Court held that the appellate authority may entertain a new legal ground if facts are already on record. There's nothing on record. I would be very happy the government should collect tax what is due to it, but within the legal scheme. However, the judgment also proceeds on the basis that there is a valid appeal before the appellate authority. The appellate jurisdiction has been properly invoked. It does not authorize an appellate forum to revive a time-barred or non-maintainable appeal. Let me give you two latest judgments of Supreme Court. One I discussed with you the other day. First is M. Lalita versus Sampson and Sons, 12th May 2026. It's again IBC, but same principle. This was again, appeal was filed late. The appeal was filed before NCLT against NCLT order. The appeal was filed without certified copy of the implement order. Here also the same case, which was a mandatory requirement under NCLT rules. These are tribunal rules. The defects were cured later and appeal was refiled. Now my friend is asking for adjournment, you can refile the appeal. So what will happen then? That's what the Supreme Court says. After the expiry limitation period, NCLT condoned delay in filing and refiling. They condone delay. Matter is Supreme Court. NCLT will go to Supreme Court, don't go to High Court. The Supreme Court set aside the NCLT order and held that the appeal was not merely a defective appeal.
I'm sorry, I just was remembering. NCLT orders go to NCLAT and thereafter it goes to...
sir, NCLAT के order है. Thank you so much. It's an NCLAT order.
You said NCLT, that's why I was worried.
The appeal was not merely a defective appeal, it was wholly incompetent appeal because it did not satisfy the mandatory requirements for institution of appeal. The court held a litigant cannot file an incomplete non-maintainable appeal merely to save limitation. Now it can't be withdrawn. Defects cannot be cured after expiry of limitation. That is the main point. I'm going to give you one more latest judgment. Defects have to be cured within the maximum period allowed, not after this. Merely to save limitation. Defects cannot be cured after expiry of limitation to revive a right which has already extinguished. Procedural rules cannot override statutory limitation. A benefit of technicality or procedural limitation knows no equity. It moves both ways, against revenue, against... If your order is time barred, can an officer say, my wife was not well, therefore I did not pass the order? If the order was unsigned, can he say, it's a mistake, I can rectify? Can the tribunal say, now you sign and we'll file the appeal? Can it be said? So if this rule applies to government, the same rule applies to the other side also. Now what is the principle emerging? This is my language. Limitation applies to filing of a legally maintainable appeal. not merely uploading papers or making an attempt to file. If the filing lacks essential statutory requirements, subsequent rectification cannot relate back so as to save limitation. What was the latest case I gave you? This is judgment also you can take. I'm also reading the relevant paragraph, the latest judgment of Supreme Court. Yes. The right of appeals, even delay in refiling defective appeal cannot be used to circumvent the statutory limitations.
Which page or paragraph you are reading?
You know, I will read it to you. It starts from paragraph 16. What we have discussed, the same thing discussed here. Can or should a litigant be permitted to circumvent the rigorous of limitation by filing a defective appeal as a device to save limitation, and thereafter to opt to cure the notified defects at its layer? Even no adjournment being sought. Can or should this court countenance such a practice? The answer to both these questions have to be resounding no, the Supreme Court language. To hold otherwise, it would defeat the object of the IBC and render nugatory the discipline of timeliness engrafted both in section 62 as well as in Supreme Court rules. Any such practice of filing a defective appeal, if encouraged, could result in a litigant dragging the process of refiling for months and still being heard on this application for condoning refiling delay, premised on the ground that IBC says nothing about refiling delay, nothing about continuation application. And that Supreme Court rules, being a procedural law, must be read in a manner to aid the rendering of substantive justice to a party who is shown. The argument taken by a friend is rejected by Supreme Court. Consequently, paragraph 17, no litigant can be permitted to subvert the statutory scheme by seeking condonation of refiling delay beyond the period of 28 days which was allowed. After having initially lodged a defective appeal, once the window of 60 days, that is 3 months, days prescribed by IBC, followed by window of 28 days, 1 month, days in refiling appeal of curing defects permitted by SCR is shut. The right to appeal stands extinguished.
Sir,
I think we have had enough of justification on that. But before we speak out, you want to say something?
yes, sir. Sir, I would like to submit that the department committed an error at the very inception of issuing the notice under section 74A instead of section 74. Yet the proceedings were...
Please limit yourself to the issue in dispute.
Sir,
Issue in dispute is...
Sir,
one second. Just, unless we split it and focus it on the point of the dispute, we will go wrong. Point on dispute is that limitation. Section 107, 4, I think. 4, where you could have got a condonation at that time provided sufficient cause was shown. On that issue, you have to say anything?
Yes, sir, I am coming to that point.
No, but they have to
only.
respond to whatever he said, not
Yes,
new
sir.
points.
Yes, sir,
Okay.
I am coming to that point only. Yet the proceedings, the department issued the notices under section 74A instead of section 74, yet the proceedings were sought to be...
Sorry. Focus
This issue
on...
cannot be taken by
Sir,
tribunal.
let me...
Not this question, High Court, not here.
No,
Sir, I request to please
Now you
let me
Only
complete.
condonation.
No, focus only on... Because,
Sir, I am coming
see,
to that point only. If you please allow me to speak.
No, but
to
this point
complete.
is not relevant. This is not discussed below.
Sir,
They
please allow.
are in appeal against 10007 order. This point is not discussed. You have not appeared.
Sir, let me please complete.
No, there is no question. Why should you waste your time of tribunal?
I will take
74,
just 2
74,
minutes,
it
sir.
doesn't
Please
matter at
allow
all.
me to
one
complete.
second, madam,
हाँ.
देखो ना, merit में तो हम तब जाएंगे.
नहीं, sir, I am not going to the merits. I am just coming to the point of condonation of delay only.
Okay, let her say.
No, speak
something.
under, not
Let-
74,
let-
74A. Then I'll have to speak.
Let her say anything.
Thank you so much, sir. Yet the proceedings were sought to be sustained by the applying the principle of substantial justice. My respectful submission is that the same yardsticks must apply to the assessee as well. If an error of the authority can be cured in the interest of justice, then an inadvertent procedural defect by the assessee cannot become the ground to shut the doors of appellate remedy. I would like to again submit that had the authority, the appellate authority, provided an opportunity to furnish the sufficient cause or to cure his defect of not furnishing the condonation application, that was within the due time of additional 1 month. If the appellate authority would have granted an opportunity to cure the defect, the assessee could have done that way, and as
Okay, now I think can we
My lord,
say
there's one
something?
more issue, very big issue. Even the affidavit is not signed.
Okay.
What do we talk on this appeal?
Okay, now
Basically, initially, when this is,
Not you, not you. No.
I agree.
No, 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 no.
Now I think
No interference allowed in
I think we have
I also sought permission being a government counsel.
I think we have heard on both the sides. Learned counsel for the defense, the revenue, he has brought in some of the very important issues. After the appeal was filed, in the normal course, we would have got a written reply and have had a chance of going into all those points. We have heard them, we feel quite forceful, anyway, very, these are some of the very important points, but we still need to go through these. We would request the learned counsel to submit those papers with a brief note of what he has submission we have made.
My lord, this is the only judgment I can give which carries everything.
Okay.
You have read the judgment. There's nothing, there's no need for this.
We will go through this.
No, but my lord, there is no need. It's a Supreme Court judgment we have
We are
given.
not saying that we just reserve the judgment and will pass a reasoned order. That's all.
Well done. हाँ, कब तक भरो? अरे चलो ना, जाने दो लोगों को यार, लोगों से क्या नहीं सुनना, वो जाएं, क्या प्रॉब्लम है? हमने अपना काम खत्म करके जाना है। ये का मतलब है कि लोग जाएंगे तो जाएंगे, हमें रोका हुआ उनको किसी को?
Second case is AR Food Services Private Limited, represented by young advocate Rajat Gandhi. The present matter belongs to the supply of food to staff, including beverages, meaning thereby the appellant is rendering a service taxable at the rate of 18%, while the appellant claims that he runs a restaurant service and taxable at the rate of 5%. ठीक है?
Good afternoon to the President and Honorable esteemed members of this tribunal. First of all, I would like to thank SV sir for giving me this opportunity to present an appeal before this honorable tribunal. So this appeal under section 112 raises two important questions of law. The first was whether the proper officer can initiate a proceedings under section 74A of DGST Act without recording and intimating reasons specifically for fraud, willful misstatement or suppression of facts. And second, under what circumstances and facts the proper officer concluded that there has been a fraud and concealment. My appeal, my lords, is basically to challenge the procedure laid down under these proceedings. First of all, there was no fraud committed by the appellant herein. There was no allegation of fraud in the orders, not in the orders, not even in the notice, and there was no statement which was required to be filed by the proper officer under section 74, subclause 3, by the proper officer. So as per the section, under section 74A3, I'll read that to you, my lords. Wherein notice has been issued for any period under subsection 1, the proper officer may serve a statement containing the details of tax not paid or short paid or erroneously refunded or input tax credit wrongly availed or utilized for such periods other than those covered under subsection 1 on the person chargeable with tax. So there has been no statement filed. If you see the show cause notice, my lords, on page number 16, there has been no statement filed.
See, this statement is in relevance to an issue where SCN has already been given and there is a repeat violation. Your case is different. Just read it again. दिस स्टेटमेंट इज रेलिवेंट टू, एक डिटेल्ड शो काज नोटिस पहले दे चुके हैं, उसी का रिपीट एक स्टेटमेंट और फैक्ट्स एंड फिगर्स हैं, और उसको कहो विद रेफरेंस टू दैट शो काज नोटिस दिस स्टेटमेंट इज आल्सो बी पार्ट ऑफ इट, इट गेट्स एडेड टू द अर्लियर शो काज। ये यहाँ पे टू माई माइंड यहाँ पे रेलिवेंट नहीं है। ओके, गो अहेड, बट वी डोंट वांट टू डिस्करेज यू।
Yes, sir. Yes, sir. Coming to the other point was that there has been no fraud, concealment, or any misstatement by the appellant herein. The Honorable High Court, Allahabad High Court in Messrs. Singh Electrical Store versus Superintendent CGST has categorically held that any proceedings under Section 74, any orders passed, it's a division bench judgment, which says that any proceedings under Section 74.
74 इसमें लिखा कहाँ है? शोकाज में तो कहीं 74 है नहीं। 74 covers both.
Yes, yes, yes.
74
So that is what I am coming to. So it categorically says the order should mention that there should.
ये 74 में था।
Yes, yes.
74A doesn't mention, वो दोनों के लिए, वो कभी भी चेंज कर सकते हैं।
Adjudicant officer what he wants to do.
8-9 he has to mention 74 with due respect 74A subsection 8 or 9 he has to mention whether it is fraud or not. Yes. If he is mentioning only 74A,
No, but then also says if only when he passes the order he has to mention. It's a showcase notice. It's only showcase notice. There's no need.
Yes, sir. I'll come to the brief facts.
As far as I can see, order in original में भी कहीं fraud का नाम ही नहीं है।
Yes, yes. So that is what I was.
जिस चीज का आपके ऊपर एलिगेशन नहीं है, जिसके ऊपर आपका adverse
There is no allegation of fraud or suppression of facts against you.
And
then why are you taking this?
Because under section 74A is a part of previous section 74. This the proceeding should have been.
It is the combination of 73 and 74A. 74.
इसमें adjudication order में कहीं भी आपको penalty equal to tax नहीं है। That means they have not exercised the three words fraud, willful misstatement, and suppression of fact. इसमें है ही नहीं कहीं।
Yes, sir. So
you are saved of that.
Yes, yes, sir. But otherwise, my contention was that the proceeding should have been in section 73 rather than 74.
No, 73 was not in existence. 73 was not in existence in 24-25.
For your period is 24-25. 24-25 में 74A लागू हो चुका है, और उसके दो पार्ट हैं। एक तो एसेंशियल चीज़ है कि नॉन पेमेंट ऑफ टैक्स, एक्सेस अवेलमेंट ऑफ ITC, रॉन्ग रिफंड एटसेट्रा, प्लस जो एलिमेंट हैं फ्रॉड, विलफुल मिसस्टेटमेंट। ये सेकंड वाला एलिमेंट आपके ऊपर है ही नहीं। यू आर फ्री फ्रॉम
24-25 के अंदर 74A आ गया था। 73 और 70 जो 4 है वो एग्जिस्टेंस में ही नहीं है। तो जब एग्जिस्टेंस में नहीं है तो आप क्यों उसका ग्राउंड ले रहे हो?
Pre 24-25.
Right.
But it says override.
Yes, sir. Yes.
From the
Rather
So you once you read judgment, I was telling you in the morning, don't jump with judgments. You will draft a wrong appeal.
Okay, now draft it.
जो आप कहना चाह रहे थे, जो रिलीफ लेना चाह रहे थे, वो ऑलरेडी आपके पास है।
So now I will come to the main dispute which was there in the impugned order. So the appellate authority failed to consider that the appellant was providing a supply of food rather than services under the. So they took took reference of two notifications passed. One notification was notification number 11 by 2017, which was subsequently amended in the year 2019, and wherein they have stated that the appellant herein is providing a service rather than a supply of food like a restaurant. And their main contention was that the appellant did not provide those services through a premises. So the appellate authority failed to consider the agreements which were filed before them. That so I have filed those agreements, and I was under a obligation to provide the supply of food through a premises, and the appellate authority failed to consider the fact that there were premises from which I was supplying the food to my kitchen partner and the other corporate partners. So I have filed this kitchen agreement and service agreement, and as per clause 4 of the service agreement on page 24, may I kindly come to page 24,
You are mentioning service
25.
agreement.
Yes, yes.
You are mentioning service agreement on your own.
Yes, yes. So that is what I am saying,
If
that
you are saying that you are providing the services and your agreement says that,
But-
that you are providing the services, it
But-
means the services is taxable at the rate of 18%.
no, but it was for
How
the
can you
supply
claim the-
supply of food. I am talking about the notification. Notification.
You are asking for the notification, but your statement is saying, your agreement is saying that you are providing the services.
Yes, yes. So that is what I am coming to. The appellate authority did not taken that I was providing it through premises, through a premises.
It
So
is
there
not
was
necessary to-
premise. I have taken premises
You are
on
not
rent.
manufacturing the food. You are not manufacturing food. Your kitchen, just see your agreement.
So, इसमें
Just see your agreement. Your agreement clearly says that you are not manufacturing the food. You are providing the services.
No, but I think ITC is not under dispute in this present.
they are
plea.
claiming input tax
It's just a
credit.
classification of tax. Tax rate is under dispute.
Actually, you had two options. Okay, assuming everything is correct, you have two options. Pay tax at 18% and avail ITC. Pay tax at 5. Okay, अभी उसको split नहीं कर रहा मैं आपको. चलो आप एंड.
anything, please,
No, I'm okay, sir. Saying.
please.
My lord, their agreement, just see the agreement. Agreement says that they are providing the services. They have attached the kitchen agreement. That doesn't mention that they are providing the food and they are manufacturing the food. Their agreement clearly, बाकी तो मैं बाद में जाऊंगा कि उनका agreement ही यही कह रहा है कि they अपने आप ही claim कर रहे हैं कि वो service provide कर रहे हैं.
May kindly
But
see
they
the
are claiming
notification,
the input.
the amended notification.
If you are going for in the restaurant services, then how can you claim the input tax credit? Your order says you are claiming input tax credit and you didn't attribute it. On 5%, how can you claim the input tax credit?
I think there was a misclassification of interest. Here, this is not a case of fraudulent ITC availment. So this is a case of misclassification of interest
No.
from 5% to 18%.
Just we will see the definition of composition, composite supply. Section 2, subsection 30.
Yes.
A composite supply consists of two or more taxable services, mutually bundled. They are providing the services where the service is their main part and the food is इनका जो है वो आपका secondary issue है. क्योंकि
Now
they
tell me one thing. How you can say that this is the principal supply service?
because if we go for if we go in the restaurant service, restaurant service में we should have a kitchen or a cloud
Listen,
kitchen. We
please,
should
please,
manufacture the food.
See,
They are purchasing the packages and providing.
46, page 46. See, page 46 is clause 32. Restaurant service means supply of
46 किस पे?
46
paper book
of the appeal.
page 46.
Yes.
Clause 32. Restaurant service means supply by way of or as part of a service of goods, being food or any other article for human consumption or any drink provided by a restaurant, catering joint, including mass, canteen, whether for consumption on or way from the premises.
Away from the premises,
or
where such
any
foods.
other article for human consumption for drink is supplied. So that is applicable on any other place. So
Yes.
under the circumstances, the principal supply comes a supply of food, drink, which is for human consumption.
Yes. Now we will come to the शेड्यूल 2, आप शेड्यूल 2 में भी आ जाइए.
No, see, service, here it is
Restaurant
restaurant
service में
service.
देखिए, वो जो notification था.
Yes, schedule 2 says the same language has been used.
Same
in
language
schedule.
is used.
Yeah. Service, that is, so
नहीं,
restaurant
that-
service, that is.
शेड्यूल 2 में आपको
restaurant
शेड्यूल
service.
2 पढ़ता हूँ. शेड्यूल 2 है सप्लाई बाय वे ऑफ और एज पार्ट ऑफ द सर्विस और इन एनी अदर मैनर व्हाटसोएवर ऑफ गुड्स बीइंग फूड और एनी अदर आर्टिकल फॉर ह्यूमन कंजप्शन और ड्रिंक अदर देन अल्कोहलिक liquor or human consumption where the such supply or services supplied for cash or
The
deferred.
focus is on supply of food, drink for human consumption. So, convenience and they are ancillary, they are not the principal supply. Principal supply is food.
प्रिंसिपल सप्लाई अगर इनका आप एग्रीमेंट देखें एज पर देयर एग्रीमेंट यू जस्ट सी देयर एग्रीमेंट
Yet because they don't have their own kitchen, they are.
they don't have own kitchen, they have just
in restaurant
they have
service,
just taken the
participants of
premises
kitchen is
to
not
to
mandatory.
store the food, not to manufacture the food,
To serve food.
to serve, not serve food, to preserve the, to store the food.
No, the agreement is always says that it is to serve food at the client's place.
Client's place pe they are providing the services, not on their at their own place. I'm just
Again, I don't yes. What is restaurant?
yes.
Sir, time.
Agreement.
Restaurant service means supply by way of or part of any service of goods, being food or any other article for human consumption or any drink provided by a restaurant, eating, joint, including mess, canteen, whether for consumption or away from the premises. Away from
But
the
but
premises.
but their services is relating to providing the food. They are collecting the, they are purchasing the food, they are packing the food, they are transporting, they are doing each and every little bit जो भी ancillary works होती हैं. तो उनका जो agreement है, that was for the supply of services, not for the food. Food was not a major item.
My lord, just see the agreement. It will clear the issue. Sorry, I'm assisting in.
No.
Just see page number 23. There's no need to debate this case at all now. AR Food Services Private Limited, a company having its of so and a company, hereinafter jointly referred, whereas service provider is engaged in supply of food and beverages to various companies for their staff. Customer is desirous of availing services as further provided by this agreement. I'm not saying that this is, they can write anything. It cannot be a substantive part of agreement. Let's read further now. The agreement consists of body of this agreement next to one. The body contains standard general provisions applicable to also. Then 1.3 contains the description of services. It's not food.
They are using.
Wait. Learn how to read agreement. And the time schedule for delivery of such services, which can never be a restaurant, as well as additional specific condition details adopted by type of services purchased by service provider from customer under this agreement. He is not doing anything. Both the body, in case of discrepancy between description of services and time schedule and the description of services and time schedule, the agreement prevail. In case of discrepancy between provision in the body and provision so and so, the provision in the body shall prevail unless is so and so. Now, Article 2. Customer shall order services exclusively. Restaurant is not never exclusive, sir. Never. Anybody can walk in and have to serve. Exclusively for itself and its staff, unless and to the extent provided by Annexure 1. The contractual relationship between service provider and customer shall solely be governed by the terms of the condition of the agreement. Service provider, therefore, is not bound by and expressly rejects customer general conditions or services and any additional or different terms of provision that may appear on a proposal, quotation, price list, acknowledgement, invoice, packing slip or like basic performance. With due observance, performance services organization He has to organize, ensure quality, ensure time delivery, and subcontracting reporting of progress. You can't quote a definition and get away with it. Again further, the service provider agrees to perform the services by exercising due skill, speed and care at a level generally required for well-reputed service providers in the same field as in one converted by this agreement, and shall make every effort to best of service providers' ability to serve the interest of customer as much the party. This is not a agreement for food at all. This can never be. The principal supply is service, food is ancillary. Therefore, covered by Schedule 2.
Council, the dominant factor has been established by the opposite.
And you know, in a composite transaction, the case of BSNL Supreme Court, that is there. That they said, you have to see what is the dominant purpose. By reading this agreement, can my mind stretch with the supply of food? Will restaurant give these kind of guarantees to you? And there are further very imperative conditions they have been put. Therefore, this appeal has no merit in my opinion.
I am not disputing the learned counsel contention that it's a composite supply. However, if you see the order of the appellate authority, they say that the food may be prepared at a premise or at a different place, and the food may be consumed at the premise or taken.
That doesn't matter.
Service or supply. So service that is taxable at the rate of 18%, and you are eligible to take input tax credit.
Section 8 says, in a composite supply, the tax applicable to principal supply shall be applicable to ancillary supplies also. थोड़ा agreement ध्यान से बनाना था, you could have done this.
So my case is supply of food, sir, only.
नहीं, वो तो आप बोलोगे ही. And not only that, Your Honor, they are already charging 2 rates.
We are delivering food just like restaurants, sir.
Okay. Shall we conclude now? Yes. We have heard the contention from both the parties. Thank you very much for your inputs. Hearing this and also reading para 6B, Schedule 2 to the CGST Act, there is no doubt about the fact that supply of food and serving the food is a service. And now the issue arises under what para of the this order it will fall. I have seen this food supplied at a place which is without air conditioning, food which is supplied at a restaurant which is air conditioning, and food which is supplied which has a attached with a hotel having a tariff. उस तरह के classification में your supply does not fall into any of these except the residual category. And in residual category, this is a one item composite supply, and it is taxable at 18% with the admissibility of the ITC. So with this, we find that your appeal, my apologies to say that, but doesn't stand the test of this particular situation. But thank you very much for your presentation. And
Very good attempt. It's a very difficult case. You made out very well, but experience, little more experience, you will win.
Case 3, RK Enterprises. The matter is represented by Advocate Rohit Sharma, who has come all the way from Faridabad. He is a young professional eager to learn. The matter is that the appellant has taken registration on the basis of rent agreement, but did not start the business for a period of 9 months up to October. But suddenly in the month of November declared huge turnover, the registration has been cancelled with respective effect from 1/2/2024, alleging the firm is fake and all the purchase made by the appellant is made from bogus firms.
Before we start, because I have observed one discrepancy, all of these 5 of you. See, when you come before the judgment, you have to ensure the complete synchronicity right from getting SCN, your reply before the jurisdictional officer, then your facts before the first appellate authority under section 107, grounds of appeal, your submission and
अरे
everything you have
आधे
said
घंटे में खत्म कर देंगे.
are you take all
अपनी वो वाली
relied upon documents.
लैपटॉप
ये तो सो रहे हो.
लिखा हूँ
क्या
मैं
तो सो रहे हो.
All are duty, whatever the relied upon documents during the process from the jurisdictional officer to the first appellate authority, you have to enclose with this. Sir,
लास्ट वाला है.
You have like you have not placed anything. Secondly, every page that way you have signed, you have not placed
विकास ऑन कर दो.
list
Challan of your filing fees. So, because you have come before the tribunal, so whatever relevant documents you have to place to strengthen your claim. So that way it suffers from procedural lapses, right? Everything synchronologically you have to attach. That will strengthen your claim. Anyway.
Good afternoon, all the members. Hello. मैं एडवोकेट रोहित कुमार शर्मा आर के इंटरप्राइजेज के केस को रिप्रेजेंट करना चाहता हूँ. अगर आपकी इजाज़त हो तो मैं आगे कर सकूँ. उससे पहले सर मैंने 5 जून को अपील फाइल की थी. उसमें स्टेटमेंट ऑफ फैक्ट से रह गए थे कुछ. वो मैंने आज दी है रजिस्ट्रार साहब को. अगर आपकी इजाज़त हो तो इसको पर ये मोबाइल में है.
मेरे पास कभी वो भी नहीं है.
गवर्नमेंट का नहीं दिया तो था, निकाला नहीं आपने.
Milord, I didn't get any facts of today, so may I request for the adjournment? मेरे पास कुछ है ही नहीं इनका.
कल दे दी.
We will see in the next. We will
Adjourn for the
here
next
here in the next next meeting.
Clear all the facts next month, but this is I have gone through the entire file.
I don't have any facts, sir.
I just want to state
Additional facts.
4 or 5 appeals, nothing has been, no appeal has been prepared very well except Yugal's appeal. Every appeal.
Don't say that.
क्यों? नहीं कह सकते.
नीचे जाके कहना. वहाँ जाके जब चाय पी रहे होंगे जो मर्जी कहो. Now you are wearing a hat.
Okay.
ठीक है.
Thank you, sir. Okay.
ABC Services Private Limited, represented by young advocate Vishal Sharma. Another. This is very interesting case where the appellant has purchased the human hairs from a temple and paid rupees 10 lakh as the fee to collect the hairs. The amount had not been declared in turnover and hence not depositing the tax. License fees, and the amount is not declared in his turnover, hence not depositing any tax. Please hear Advocate Vishal Sharma on this very interesting case, and the government revenue will be represented by our CA C.K. Gupta ji.
Good evening, everyone. Myself, Advocate Vishal Sharma. First of all, thank you to the DGST group for providing me an opportunity to appear in this moot court. I filed my appeal on 5th of June minutes, and there was an application. There was 3 documents which were skipped to file, the APL 202 and APL 05, along with the challan, which I filed, and I hope the opposite counsel has also got the copy for the same.
Yes, I have
Yes.
just now received the copy.
In the morning itself, I guess.
ABC one.
It's ABC Service Private Limited
Addition
versus.
document.
Mr. Counsel, you have not filed the main documents, APL 5, APL 2, challan for filing the
Madam,
fees
I
and all
have
that.
filed the
How
appeal.
we can entertain your appeal?
Madam, I have filed the appeal on 5th of June, that is Friday, and on the Monday I had made the call to the registrar regarding the same. So as per the registrar instruction only, I am sending it I filed it today morning. I would have filed it Monday only, but as per the registrar advised, as per the advice only, he said that it will be accounted on the day of hearing along with the application for this additional document. That's why I have filed today, my lords. There were only three documents, APL 02.
Today only, and I think this is an afterthought. They are filing the additional documents today.
Malab, I could have filed.
How they can say we have already filed the APL 05 and APL 02?
Since you have got the documents today, now you want to argue, you want a time.
कर लेते हैं argue.
Because I could have filed it Monday itself, but
if you want time, you go through. अपने आप को खुद ही contradict कर रहे हैं.
Okay, give us an adjournment.
Because if this I would have filed out in Monday, but as per the instruction, though.
Adjournment is subject to the condition. और भी कोई limitation आपको लगती है, go through once again, read it 3, 4 times, 5 times,
We'll do
and
it.
prepare yourself well.
We'll do it, my lords.
Adjournment is granted.
It's also an order.
We'll do it, my lords.
You should live for another day.
You need extra work on this. You are lacking on many points. It doesn't look like an appeal. It's nowhere you have addressed the forum. It's not looking a appeal.
Ultimately, तो dismiss ही होनी है.
एक मिनट के लिए मैं ब्रेक चाहूँगा.
Yes, yes.
Longest ever day of DGST group. We have never sit up to this time ever. Thank you so much. And thank you for our judges.
लेकिन ये पता नहीं लग रहा 5:30 बज गए. मैंने तो अभी देखा टाइम.
So now maybe the convener thinks we'll all have dinner at his cost. अच्छा हाइटी तो होगी, हाइटी तो है ही है.
सर हाइट ही अभी तो इतना सारा खाने के लिए है अभी तो. सब कुछ है, बहुत सारी चीजें हैं. पकौड़े भी है, ढोकला भी है, ये भी है, वो भी है. विशाल की अपील की तो बहुत ही बुरी हालत है. विशाल की अपील की तो बहुत ही बुरी हालत है. नहीं सर आ रहे हैं.
My Lord, with your permission, may I state his legal proposition in this case?
Please.
On behalf of my friend. His appeal was dismissed as time barred, first appeal, by 1 day.
Yes.
Delay by 1 day, beyond 3 months, 4 months, beyond 4 months.
Yeah, beyond 4 months.
Right? He is before this Honorable Tribunal with a proposed application to the Joint Commissioner for condonation of delay. The naked eye, this tribunal has no power to condone delay beyond 4 months. But he has taken a legal issue, interpreting section 1071. He says when order was passed on 16/12, he was in hospital, medical documents have been attached. The order was served on his employee Shiv Kumar on 17/12. But it was communicated to him on 21. So there's a difference so far as we know between service of the order and communication. Right? There are judgments for or against. But the Supreme Court has stayed the judgment of Allahabad High Court latest where distinction was drawn, but it's only state. There is no judgment of Delhi High Court in this issue. I have the Supreme Court judgment with me. It's a case of State of Uttar Pradesh versus Bambino Agro Industries Limited. The issue was whether when you put an order on portal or service, whether this service amounts to communication well in section 169 subsection 2. Allahabad High Court had distinguished that limitation will start in 1071 from date of communication, that's the words used in 1071. But Supreme Court has issued notice and put a stay till the next date of hearing. Now the only issue before me as a Revenue Counsel and before the tribunal is, do we wait for this order or this Honorable Tribunal wants to hear and show its indulgence?
In fact, issue to my mind is rather clear. In section 169, which impinges upon, which obliges the authority to send the order, their word use is tendered.
Yes.
They send it.
Yes.
Whereas section 107(1) is very clear that from the within 3 months of the date of the communication.
Yes.
Simple literal meaning of the word communication to my mind is it is communicated when it is communicated. Under the Indian Contract Act also there is a very, very clear illustration to that. Communication, send it when it goes out of my hand.
No, but that's the context in the context of
I know,
section 4.
I know, but communicated means...
that context may not be relevant here because we are dealing with a special limitation statute. Contractor was not dealing with limitation. But here Supreme Court has put a stay on Allahabad High Court this interpretation. My question is this.
What do we, should we put it into the waiting the way we used to do in the call book, or you want to, okay, I leave it to you.
No, I'll be in your hands. I have no doubt there is a sufficient cause. There is sufficient cause.
I do agree, but I have also seen through the medical papers and everything, and we can't say that this not submitting the appeal on file was nullified or something like that. The fellow has been running tooth and nail. See the document, the medical
Yes,
certificate.
verified,
There's an affidavit as well.
Affidavit
Everything
also.
is very
Everything
well
is well done. To that extent, we take the liberty of condoning it. Even if you want, you may go.
No, but this tribunal cannot condone delay. You have to tell the first authority to consider condonation. He has filed an appeal. There's the application filed before tribunal. Let him file the same application before Joint Commissioner. Let him decide.
We remind the case back to the first appellate authority and to consider the revised request.
Condonation application.
The condonation application. Matter ends.
Obliged, sir. Thank you.